3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we walked through July 6, 2019. Today we are following the evidence seized through the documentary record, so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with CDs labeled name plus young. That is where the paper trail becomes specific and testable.
It really is. That specificity is everything. The public conversation is filled with a lot of noise, a lot of speculation.
Rumors, theories.
Exactly. But when you open the EFTA seizure records, the noise fades. You're looking at the raw data. You're looking at the chain of custody. It's about what federal agents physically took out of that mansion on East 71st Street.
And maybe more importantly, how they documented it.
Or in some really critical instances that we're going to see, how they failed to document it.
That failure seems to be the central issue here. The gap between what was seized and what was logged. I want to start right there with the physical media. The story has always been about the tapes, these almost mythical recordings. But the EFTA documents, they give us a much more precise starting point. I'm looking at the seizure log now, document EFT 000300741. What are we actually seeing here in this file?
Okay, so this is a foundational document for understanding the evidence. It's not vague. It explicitly establishes the existence of 4 specific CDs that were seized by special agents.
So not just a box labeled media, it itemizes them.
It itemizes them, but for the context of how they were found, you need to cross-reference that with another file, EFTA 000024584. This is more like an officer's field notes. It gives you the color.
I have it here. It details the discovery, and it notes, quote, compact discs with handwriting found during the search. And this brings us right to that labeling system we started with.
The notation.
The notation in the records is incredibly specific. It reads name plus young.
And we have to stop right there and analyze what that means from a forensic perspective. This isn't a rumor from an online forum. This is a cataloging system documented in federal seizure logs.
What does that tell you, a cataloging system like that?
It suggests a sorting methodology. The owner of these discs was categorizing his collection. Handwriting on physical media like this, it's considered a contemporaneous label. It tells you the creator's intent or how they viewed the content when they made it. It's a primary data point.
So it's not just a random pile of discs. It implies there's a system at play.
A very deliberate one. It implies a specific categorization based on that descriptor, young, which is attached to a specific name.
And in the context of this specific investigation.
A sex trafficking investigation. In that context, that descriptor becomes powerfully evidentiary. It suggests the person was making a clear distinction between, say, business contacts or social acquaintances and another subset of interactions, a subset that required that specific label, young.
It's a very cold administrative way to organize abuse. It turns it into a filing system.
It does. But this is where the record immediately gets complicated. It shifts from what was found to how it was handled by law enforcement. You mentioned gaps earlier.
I did. I'm looking at 2 documents now, EFTA 000000000000021. These appear to be internal FBI communications about the raid itself.
And they contain what you could only describe as a stunning admission about their own inventory process. If you read the text, it says, and I'm quoting here, media such as VHS tapes, cassette tapes, and CDs will not be. The FBI did not prepare an inventory of their evidence when they seized it.
I want to pause on that phrase. Did not prepare an inventory. This is one of the highest profile federal raids in recent history. A massive mansion in Manhattan. A suspect with global connections. How is it possible that a federal agency does not prepare an inventory of seized evidence at the scene?
It's a major departure from standard procedure, from standard chain of custody protocols. You know, in any normal forensic seizure, even a small one, every single item is bagged, tagged, and logged right there. At the point of seizure,
You create a field inventory.
You create a field inventory. You write down 1 Memorex CD, handwritten label X, found on the desk in the upstairs office. You do that to ensure that what arrives at the forensic lab is exactly what left the crime scene.
Without that, the chain of custody is broken.
It's not just broken, a gap is introduced. By admitting in their own documents that an inventory wasn't prepared at the moment of seizure, the Bureau creates an opening for any defense attorney to argue contamination, mishandling, or that the evidence isn't what they claim it is.
So let me get the mechanics of this straight. Agents are literally walking out of that townhouse with boxes of potential evidence, but there was no master list created at the door confirming what is in those boxes.
That is precisely what the documentation suggests. It suggests a bulk seizure with the intent to inventory everything later, back at the office.
But that creates a huge audit trail problem.
It's a massive break, because if you can't prove that the CD you analyzed in the lab in October is the exact same CD you took from a safe in July, the evidence is vulnerable. For our purposes, it means we can't trust the initial seizure. We have to rely on the post-seizure processing logs. We're trusting what they said they had after they got it back to an FBI facility and opened the boxes.
And that delay in just processing the items, that leads to another document, EFTA 0000023952. It has a note about the scanning status of these disks.
Right, and this highlights the lag time. The document notes, quote, "The label on the disk seems to suggest it, yet been scanned."
So you have the physical seizure on July 6, 2019. But the actual digital forensic work, the part where someone puts the CD into a secure drive, images the contents, hashes the files to preserve them,
Yep.
that happens much later.
Much later. And this document shows that even with a label that suggests high-priority content, that specific disk had, quote, "not yet been scanned" at the time that entry was made.
So for a period of time, it could be days, it could be weeks, these CDs, explicitly labeled with names plus the word young, are sitting in an FBI evidence locker, but they are effectively black boxes, unexamined.
That's it, exactly. And in that window, the public narrative is exploding, but the actual physical evidence is just sitting there. That lag time between seizure and analysis is where institutional inertia can really damage a case. It silos the information.
How so?
Well, the agents who are on the scene, they know what they physically took. They saw the labels. But the prosecutors who are trying to build the case for a bail hearing, for example, they don't have the digital contents confirmed because the lab is backlogged or hasn't processed it yet. It creates a critical disconnect between the physical evidence and the legal strategy.
Okay, let's pivot to the second block of evidence here. The photographic record. We know photos were found. Media reports at the time were filled with descriptions. The CNN archive, source 2JPF6PUP, describes a vast trove of photos.
A vast trove, yes.
But we need to be very careful to differentiate between what the media was reporting and what the Department of Justice records actually state was on that media.
This distinction is absolutely vital. It gets to the heart of public expectation versus the reality of the court filings. If you pull up document EFTA 0000069979, it contains a very specific note. It's an analyst's note about the seized media.
And it says,
It states very clearly, the CDs from NY only contained pictures, no video.
no video. It's a huge statement. It seems to fly in the face of everything we've heard, all the witness testimony about surveillance systems, hidden cameras in every room.
It contradicts the expectation of video, yes. But here's the nuance you have to catch. It contradicts the expectation of video on those specific CDs, the ones seized from New York.
The ones with the handwriting.
Precisely.
Yeah.
Now contrast that note with another document, EFTA 00028845. This is an internal request from investigators. And in it, they are specifically asking for analysis of the images and videos seized from Epstein's mansion.
So wait, the investigators were looking for video.
They were actively hunting for it. They were requesting forensic analysis of hard drives, not just CDs, looking for video files. But the specific forensic report that came back on those New York CDs, the ones labeled name plus young, was that they contained static images, pictures.
So the label, name plus young, on those 4 specific discs led to photographs, not films.
According to that one specific document, that's the finding. But this whole topic of photos got even more confused when the estate documents were released.
What? The December 11th batch, I remember that. A set of 93 photos was released, and many people assumed this is it. This is the evidence from the mansion.
And that's a critical misunderstanding. You have to look at the metadata for those photos, the digital fingerprint.
The timestamp embedded in the file?
Yes. And the source file, Epstein Island Pictures and Videos 03122025. It gives us the forensic breakdown of those estate photos. The metadata, the exec-epis data, it shows that most of those pictures were taken on October 2, 2020. There are drone pictures taken on October 7, 2020.
Jeffrey Epstein died in August of 2019.
Exactly. So these are not his photos. They are not evidence of his crimes.
What are they then?
They are post-death documentation. They were almost certainly taken by the executors of his estate, or maybe for a real estate appraisal. They're cataloging the property for liquidation. They show the rooms, the art, the weird custom chessboard. But they are legally and forensically distinct from the evidence seized by the FBI in 2019.
It's crucial not to conflate the two sets.
You cannot. The vast trove that was seized in the 2019 raid is one data set. The 2020 estate photos are basically just administrative records for probate court.
Still, the volume of what was seized in 2019 was significant. That vast trove description from CNN doesn't sound like hyperbole. But it does feel like the DOJ in its own documentation is trying to manage expectations about the nature of that content.
By specifying pictures, you mean?
Yes, by specifying pictures and no video on those key CDs.
It could be a minimization strategy, sure. Or it could just be precise legal and forensic categorization. By separating pictures on CDs from potential video on hard drives, they are creating distinct evidentiary categories. But we have to be clear. A static image can be just as incriminating as a video. The label, name plus young, was on the disk itself. Whether that disk held 1,000 JPEGs or a single MPEG file, the intent behind the label remains the central point. The content was separated out for a specific reason.
Okay, let's move from the digital evidence to the physical papers. The documents, everyone talks about the Black Book. But the search of the mansion turned up more than just that one book. It showed a habit of meticulous, almost obsessive documentation.
It did, and you see it in document EFTA 000285868, which describes the search of the kitchen.
The kitchen. Not a lock study or a hidden safe.
No, the kitchen. This detail tells you so much about the operational security, or really the complete lack of it, inside that house. The document says, quote, "The kitchen was searched and taken into evidence was a cell, along with a message book, was seized."
A message book, just left in the kitchen. We're not talking about a secret ledger here. This is something that would have been on the kitchen counter.
It implies a total normalization of the activity. I mean, think about the traffic in that house. The staff, the guests, the victims. The kitchen is the central hub. To have a message book lying out in the open in the kitchen means the network isn't a secret within the walls of the house.
It's just part of the daily domestic routine.
Right. Message from Prince Andrew, Ghislaine called. It documents the inbound and outbound traffic of the entire network in real time.
And that network traffic is then mapped out more formally in the Book of Black. The source we have is the Book of Black, 1991-2025 edition, which is a compilation of the famous Little Black Book, and another one, the Safari phone book from around 2004 or 2005.
The Book of Black is the topology of the network. It's the map of influence and access. You see the names everyone talks about: Leslie Wexner, Ehud Barak, vast U.S. political networks.
But we have to be careful here. A name in a phone book doesn't prove complicity.
Of course not. That's a critical point. Simply having someone's number is not a crime. The real forensic value of the Black Book comes when you cross-reference it with other documentary evidence.
Which brings us to the flight logs. The source, Epstein flight logs. This is where the address book meets the real world. When you overlay the names in the book with the names on the flight manifests, what pattern emerges?
A repeatable pattern of movement and association. It's a two-factor authentication in a way. The Black Book establishes the connection Epstein had, their contact information. The flight logs establish the action. They physically traveled with him on his private aircraft.
So if you find a name in the book, and then you see that same name on a flight manifest to Little St. James or to the ranch in New Mexico,
you've established a physical link. You have moved beyond knowing of to associating with. You've documented a physical proximity.
And this pattern exists completely independent of the legality of any single trip. We are not saying that every person on every flight was involved in a crime.
No. We are saying the documentation establishes a persistent, high-level network of associates who had access to Epstein's private world, and he had access to theirs. The operational point here is that this wasn't some deeply hidden conspiracy. It was documented in leather-bound books left in the kitchen and an official flight manifest filed with the FAA. The secrecy was never about the existence of the network. It was about the specific activities taking place at the private destinations that network flew to.
Okay, let's turn to evidence block 4, the safe and the hard drives. This is where the search for the so-called master files or the insurance policy usually centers.
Right.
The warrant request itself, Document EFTA 000000141 is very broad.
It is. It's a standard catch-all. It requests to seize the items and evidence, fruits, and basically anything and everything electronic. They wanted all the data.
But the return, the acknowledgement of what they actually got, is in document EFTA 0000527. It's more specific. It says, the drive and CD are both available for an iPhone that law enforcement seized.
So they confirm they have hard drives, CDs, and at least one iPhone. Now, we also have this other source, Epstein Tapes 2003. This lists specific audio files with some very interesting titles.
Let me read them. Own Personality, Time Warp, Dalton School, Bear Stearns, Making Money. These, they don't sound like blackmail tapes.
No, they sound almost mundane, corporate even. Bear Stearns, Making Money. These titles strongly suggest personal dictation, maybe recordings of business calls or meetings.
Musings
Musings of a narcissist, maybe, or just business records. He was known to record his thoughts. Dalton School is an obvious reference to where he once taught, but in 2003 it's a historical reference, so it's not clear what that is.
But are these the infamous surveillance tapes? The recordings from hidden cameras?
The titles certainly don't suggest that. They don't sound like the kind of compromat that has been so widely theorized. However, you have to place this dry, almost boring inventory list next to the sworn testimony of Sarah Ransom.
Which we find in the Giuffre v. Maxwell court filings.
Correct. Ransom was a victim, and her testimony was extremely specific on this point. She claimed there were, and I'm quoting, unhackable devices containing incriminating footage and video evidence implicating high-profile individuals.
She called them his insurance policy.
She did. She alleges the existence of a sophisticated, high-definition video blackmail operation. But in that same legal document, you have to read the intervener's argument.
The intervener being a third party trying to keep their name out of the proceedings.
Exactly. And their lawyers argue that Ransom's testimony is inflammatory and, critically, that it lacks credibility. They are actively trying to have her testimony suppressed or discredited in court.
So you have this huge gap. On one side, you have a victim's sworn testimony about high-tech video blackmail. On the other, you have a DOJ lab note saying the CDs from NY only contain pictures. How do you reconcile those two realities?
That is the central, unresolved gap in the evidence. There are a few possibilities. One, Sarah Ransom is mistaken or fabricating the story about the videos. Two, the videos exist, but they were on a different form of media that wasn't part of that specific New York CD's batch.
Like the hard drives, the ones the investigators in EFT 000028845 were asking about.
Exactly. Maybe the videos were on those hard drives. Or a third possibility is that the most incriminating material was never seized at all.
Or a fourth possibility, which goes back to our first point. It was seized, but it was never properly inventoried. If you don't write it down at the door, it's much easier for it to get lost in the system, or for someone to claim it was never there to begin with.
That is the fundamental problem created by that evidence log missing entry we're going to get to. When you break the chain of custody at the very beginning, you create plausible deniability for everything that follows. We can't say for sure the video doesn't exist. We can only say the DOJ's paper trail claims it wasn't on those specific disks they chose to comment on.
Let's pull the lens back now to the institutional level. Evidence Block 5. This whole story didn't start in 2019. The patterns were visible years, even decades earlier.
That's right.
We have a remarkable document, a letter from Michael S. Ryder. He's the police chief in Palm Beach. The letter is dated May 1st, 2006. That's 13 years before the New York raid.
This letter is a primary source document that proves institutional friction at the highest levels. Ryder is writing to the state attorney at the time, Barry Krischer, and he is not holding back.
What does he say?
He writes, quote, I continue to find your office's treatment of these cases highly unusual.
Highly unusual. In the world of law enforcement correspondence, that's a screaming red flag. That's a formal accusation.
It's a documented challenge to a prosecutor's authority, and Ryder goes further. He formally urges Krischer to consider disqualifying himself from the case. This letter proves that the local police were doing their job. They were investigating aggressively. They believed they had probable cause for serious charges.
So the initial breakdown wasn't at the police investigative level.
Not at all. It happened at the prosecutorial level. The police brought a strong case, and the prosecutor's office, under Krischer, made the decision to dilute it into that infamous non-prosecution agreement.
So while the cops are fighting with the prosecutor in Florida in 2006, you have another set of eyes watching Epstein from a different angle, the financial regulators.
Yes, and this is where the Epstein Files, Corey Snofflet source, becomes so important. It details the Treasury file.
The big Epstein Files.
That's what it was called. And it perfectly illustrates how siloed federal intelligence can be. For years, the Treasury Department's Financial Crimes Unit, FinCEN, was receiving suspicious activity reports, or SARs, from banks about Epstein's accounts.
And the Senate Finance Committee eventually got access to this file.
They did, and the numbers they found are just staggering. I want to get this exactly right. They found 4,725 wire transfers worth nearly $1.1 billion in and out of a single Epstein account.
Let's just sit with that for a second. Over $1 billion. In nearly 5,000 separate transactions that were flagged by bank compliance officers as being suspicious.
This was not a needle in a haystack. This was a haystack made entirely of needles. The banks were effectively screaming to the federal government that something was deeply wrong with how this money was moving.
And the institutional failure here is described in how that file was handled. It was a closely supervised session in the Treasury building, no photocopies allowed.
Right. Think about that. The evidence of the financial network exists. It's sitting in a file at the Treasury. The evidence of the sexual crimes exists with the police in Palm Beach. But the files are in different buildings, under different agencies, and they don't talk to each other. The Treasury analysts aren't sharing the SARs with the detectives in Florida. The system was siloed.
So you really have 3 different Epstein files. The Treasury's financial one, the FBI and DOJ's criminal one, and the federal court's civil one. And they never fully merged.
They never merged. Which brings us to the most troubling gaps in the official record. Evidence Block 6. We've talked around the missing log, but I want to read the specific entry. It's from documents E, so 000002985, and EFT 000029903.
And the entry in the field just reads,
It reads, Evidence Log, missing. 2 words.
in a federal criminal case of this magnitude.
Yes, an empty field where the evidence log should be. This represents a catastrophic procedural gap. It means that for whatever items were supposed to be on that log, we have no documented chain of custody. We don't know who handled them, where they were stored, or if they were ever analyzed. It is a black hole in the official record.
And into that black hole, politics can rush in. We have the July 2025 Department of Justice memo, which is referenced in the Stofflet source. This was a major reversal.
That was complete reversal. You had the Florida Attorney General at the time, Pam Bondi, who had been leaning into the public narrative, the idea of a client list. The public expectation was that a list of names would be released.
And then the DOJ steps in.
The DOJ issues this unsigned memo, and it declares 2 things. 1, there is no client list. And 2, there is no evidence of an elite blackmail operation.
No evidence of an elite blackmail operation. How is that statement reconcilable with the Book of Black, with the message books left in the kitchen, with the CDs labeled name plus young, with $1.1 billion in suspicious financial flows?
It's reconciled through a very narrow, legalistic definition of the word evidence. If the DOJ's definition of evidence is a single physical document titled My Blackmail List that explicitly details quid pro quo demands, then no, perhaps they didn't find that specific piece of paper.
But if you look at the totality of it,
If you look at the mechanism for leverage, the vast collection of names and numbers, the documentation of messages, the photographs sorted by name and the word young, the sheer volume of untraceable money, the documents clearly establish the opportunity and the capability for blackmail on a massive scale. The DOJ memo is a legal conclusion. The physical evidence suggests a functioning intelligence operation.
so let's synthesize this. Let's connect the dots. You have the physical evidence, CDs with specific troubling labels. You have the financial evidence, over $1 billion in SARs. And you have the institutional evidence. Chief Writer's letter from 2006 and those missing evidence logs from 2019.
When you lay it all out, the pattern is undeniable. The system actually worked at the lowest levels, at the detection level.
What do you mean?
Chief Writer's detectives in Palm Beach, they detected the crime. The bank compliance officers, they detected the suspicious money flows. The breakdown was never a lack of information or a lack of signals. The breakdown happened when that information moved up the chain of command.
It occurred at the prosecutorial and federal evidentiary level.
Precisely. The audit trail breaks when it hits prosecutors like Barry Krischer. It breaks when the FBI fails to follow its own basic inventory procedures. We have clear documentation of the seizure. We know they took the drives. We know they took the CDs. We know they took the books.
But the analysis of that content,
The analysis of what was actually on those name plus young CDs, or what that $1.1 billion was actually paying for, that remains opaque. And it's opaque because of these documented institutional failures. The evidence log, missing status, and the siloed Treasury files created a fog that has yet to clear.
So the documentary record proves the existence of specific labeled media. It proves a massive and suspicious financial trail. It does not produce a single verified client list in the way the public might imagine one.
Correct. But the raw data, the flight logs, the black book, the message pads, that data serves as a de facto map of the entire network. The map is there in the files. You just have to read it.
Next time. Bail hearing.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.